This video will discuss the Battle of the Forms under the Common Law and UCC Section 2207. It will also cover some electronic contracting issues, including rolling contracts. First, let's discuss the typical transaction that we're going to be dealing with. Primarily, we're talking about a buyer or other customer who submits a purchase order or a similar form to the seller. That purchase order is going to contain terms that are favorable to the buyer, like warranties, and it will be deemed the offer. Second, our seller, instead of merely accepting everything in the purchase order, will instead send its own form, an acknowledgement or something like that. It's going to purport to accept the offer. They'll agree on material terms like price and quantity, etc., but it will contain the seller's own terms since it's a standardized form. Those terms are going to be more favorable to the seller and include things like limitations on liability. Then the parties are going to perform. They're not going to necessarily notice the different legalese on the two forms, and they will continue to perform. The problem then occurs when a dispute arises, and we have a question as to whether there's a contract, and if so, what are its terms? Will the limitations on liability in the seller's form govern, or will the buyer's forms, including warranties, etc., in the purchase order govern? And importantly, it's going to depend, for the most part, on whether you're talking about the common law or the UCC. Under the common law, when you have this kind of a qualified acceptance, a second form that purports to accept but has different forms, we have two rules that come into play. The first is called the mirror image rule, and what the mirror image rule says is that any time the acceptance is not the mirror image of the offer, meaning it has anything that's different, any different terms, etc., then it will not be deemed an acceptance at all. Under the common law, it will be deemed a counteroffer. The second rule that comes into play is the last shot rule. Under the typical transaction, after that counteroffer, the parties proceed to perform. That performance will be deemed acceptance of the counteroffer by the buyer. Therefore, the counteroffer and all of its terms will govern. The last shot, the last form that was sent, is going to govern the parties' agreement. So, under the common law, first you find the offer. Second, you find the purported acceptance, and you have to ask yourself, is that communication an acceptance or a counteroffer? Under the common law, if the acceptance is not the mirror image, then it is going to be a counteroffer. Third, did the original offeror, typically the buyer, reject the terms in that counteroffer? If so, then we didn't have an acceptance. But as I said, what normally happens is the parties don't even read each other's contracts, and they don't realize that there are these different terms there. So they go ahead and perform. And if that's the case, then the original offeror, typically the buyer, will be deemed to have accepted the terms of the counteroffer, and that form will govern the parties' agreement. Under the UCC, Section 2207 is designed to change the common law in both respects. So first, the UCC is going to change the mirror image rule, and it does that in 2207(1). It's going to be much more likely that our purported or qualified acceptance is in fact an acceptance of that original offer and not a counteroffer. Second, 2207 is going to change the last shot doctrine. This is because conduct is not going to be considered acceptance like it is under the common law. So express assent is going to be required by the original offeror of any of those new terms in the acceptance. So looking at 2207 specifically, Section 1 is all about what we do with that second form. Okay, 2207 doesn't mention the offer. What it starts out with is that second form, and what it says is a definite and seasonable expression of acceptance or a written confirmation which is sent within a reasonable time operates as an acceptance even though it states terms additional to or different from those offered or agreed upon. So let's stop right there. That changes the mirror image rule. It says that if it sounds like an acceptance, it's going to be deemed an acceptance even though it has different or additional terms. The one qualification is if that acceptance is expressly made conditional on assent to the additional or different terms, then it will be considered a counteroffer. So under 2207.1, if you use these magic words, then you will have sent a counteroffer instead of an acceptance. Otherwise, we're going to favor the interpretation that it is an acceptance. Next, under 2207, we ask, well, what happens to those additional terms that are in the acceptance? And the UCC tells us that they are construed as proposals for addition to the contract. There's a very narrow situation in which those terms will become part of the contract. They must be both merchants in the business of buying or selling these particular types of goods, and none of the three qualifications under 2207.2 must apply. Those include that the offer expressly limits acceptance to its own terms. So then we'll go back and look at the offer and see if it has magic words. Second, do they materially alter the agreement? And third, is notification of objection already given or given within a reasonable time? If any of these three factors is met, or if they aren't both merchants, then those additional terms do not become part of the contract. Importantly, merely performing is not going to be deemed acceptance of those additional terms by the original offeror. So, what happens if the forms themselves do not create a contract or do not agree? What the UCC says is conduct by the parties which recognizes the existence of a contract is sufficient to establish that contract, even if the writings do not otherwise establish a contract. In that case, what are the terms? Well, they're going to consist of those on which the writings agree, together with supplementary terms incorporated under other provisions of this Act. Importantly, as we'll see in a minute, when this section can become very important is if there is in fact a counteroffer and the terms of those counteroffer, the terms in that counteroffer are not expressly accepted, then the documents themselves did not create a contract, but the conduct shows that they had a contract. So the terms will be the ones on which the writings did agree, plus the UCC gap fillers. So back to our typical transaction: offer, qualified acceptance, and performance. Under the common law, the buyer's document is the offer, the seller's document is a counteroffer because it doesn't mirror the offer. The buyer is deemed to have accepted the terms when the buyer performs, so the seller's form governs. Instead, under the UCC, we're still going to have the buyer's document being deemed the offer, but the seller's document will be deemed an acceptance with proposals for addition to the contract unless it contains those magic words. The buyer is not going to be deemed to have accepted those terms simply by performing. Instead, the new terms will not become part of the contract unless the buyer specifically agrees to them. So this can always happen. the buyer can specifically agree to the new terms that are in the seller's form. Otherwise, they're not going to become part of the agreement unless both parties are merchants and all three of the factors in 2207 are overcome. So in other words, the offer did not expressly limit itself to its own terms, the terms did not materially alter the agreement, and otherwise objection is not made to those new terms. Looking at the magic words in 2207, remember that there are two places where there are magic words. First, in 2207-1, there are magic words that will make an acceptance a counteroffer, as long as it tracks the language of 2207-1 and says this acceptance is expressly conditional on your acceptance to my terms. The second set of magic words are in 2207-2A, when we ask, was the offer expressly conditional on the acceptance of its terms? If that's the case, then when we have new terms in the acceptance, they will not become part of the contract under 2207-2A. So let's look at what happens when you have those magic words. We have an offer, then we have an acceptance that is expressly conditional on acceptance of its terms. Even under the UCC, that will be deemed a counteroffer. If the parties go ahead and proceed to perform, then we have to ask, what are the terms? The conduct itself is not going to be considered acceptance of the counteroffer. So therefore, we will have an offer and a counteroffer without an express acceptance. But conduct will be evidence that the parties had a contract under 2207-3. The terms of that contract will be those on which the forms agree, plus any UCC gap fillers. When the magic words are used in the offer, then we have a similar analysis. Our offer then is expressly conditional and contains the language in 2207-2A. Then we have a purported acceptance, and if it is also expressly conditional, so both parties have used the magic words, then we will use the analysis on the previous slide. The parties' forms themselves will not create a contract, and instead the contract will consist of what the forms agreed on plus UCC gap filler terms. If the purported acceptance is not expressly conditional, then this is deemed an acceptance with proposals for addition. We have the offer plus the acceptance, then we look at 2207-2 to see whether those new terms will become part of the contract. Under 2207-2, the additional terms will only become part of the contract if expressly agreed to by the original offeror, because under 2207-A, the offer was expressly conditional on its terms. The second typical transaction we're going to look at is electronic contracting, which is where typically a buyer places an order over the internet, mail, or telephone. The seller charges its credit card and agrees to ship the product. When the product is shipped, there are terms and conditions in the box with the product. And the question is, are those terms and conditions part of the contract? They will usually contain things like a forum selection clause, limitations of liability, etc. So again, we have two different schools of thought here. One that says that 2207 really doesn't apply at all, even though we have a sale of goods, and the other that will apply 2207. Under the Pro-CD line of cases, the courts basically say that the seller is the offeror in these circumstances, and that as the master of the offer, the seller can say it's accepted by keeping the goods for a certain amount of time. So the analysis there is that the buyer's order is a request for an offer rather than the offer itself, as in typical case. The seller is the one who submits an offer by including terms with the shipped goods. The buyer then accepts those terms by not returning the goods in a certain amount of time as specified in that agreement. For example, by keeping the goods for 30 days, you accept these terms and conditions. This way of analyzing obviously favors the seller. The other way of looking at this kind of contract under the Clocheck line of cases does apply 2207 and is more favorable to the buyer. As in the typical case, the buyer's order is considered the offer, which the seller accepts by charging the credit card, agreeing to ship, etc. So the contract is formed at the time of the order itself. When those additional terms are included with the goods, that is a proposal for addition to the contract under 2207-1. Those terms will not become part of the contract under 2207-2 unless they are expressly agreed to by the offeror. In the typical case here, both parties are not going to be merchants because we're going to have a consumer making the purchase. If both parties are not merchants, then under 2207 those terms only become part of the contract if the offeror, the buyer, expressly agrees to them.